The 14th Amendment guarantees liberty and the equal protection of the law to every American. When a state refuses to recognize a marriage of two people of the same sex, is it violating those principles? Or when the federal government decides not to recognize a marriage that is legal in a state, is that a federal overreach? These are the questions that are before the court in two cases in 2013. However the court decides the cases, they raise underlying and enduring questions about liberty that all of us should care about. One case challenges a California state law, popularly known as Prop 8, which was passed by the voters of the state in a referendum in 2008. Prop 8 amends the state constitution in California to ban same-sex marriages in that state. The California case challenges Prop 8 on two different grounds under the United States Constitution. First, it denies the principle of liberty in that past cases have determined that every American has the fundamental right to marry. And second, the challengers say that the equality principle is violated because same-sex couples are denied the status that opposite-sex couples have. The second case is a challenge to the Federal Defense of Marriage Act, which was passed by Congress and signed by President Clinton in 1996. DOMA limits federal recognition of marriages to opposite-sex couples. This means that it denies to same-sex couples more than 1,000 benefits that are otherwise available under federal law. For example, the plaintiff in the case, Edith Windsor, was presented by the IRS with a tax bill of more than $363,000 when her wife died. An opposite-sex surviving spouse wouldn't have had to pay anything at all for inheriting wealth from her deceased spouse. Under DOMA, same-sex spouses can also be denied health insurance, immigration rights, and Social Security rights, among many other benefits under federal law. So the first question in the DOMA case is, what is the justification for treating same-sex couples and opposite-sex couples differently under the law? As in the Prop 8 case, this raises the question of equal treatment under the law. But there is a second important question in the DOMA case, and that is one of federalism, the proper allocation of authority between the federal government and the state governments. Edith Windsor and her wife were legally married under the laws of New York. Historically, the states have had the power to define marriage. In passing DOMA, Congress claimed a power that it had never before had under our Constitution. The framers, on the other hand, thought that federalism, respecting state authority, was an important structural guarantee for the protection of individual liberty. Decisions in both of the cases are expected by the end of June 2013. There are many possible outcomes in these cases. For example, in the DOMA case, I think the Supreme Court should rule that there is no legitimate federal interest in denying recognition to validly married same-sex couples. So I filed a brief in the court asking it to strike down DOMA on federalism grounds. But the justices may not agree, and you may have your own opinions as well. So what do you think?